Since deliberations play an important role in reaching a decision by the arbitral tribunal, it becomes important to discuss the psychology behind reaching a decision, especially by a party nominated arbitrator. In international commercial arbitration, from time to time, concerns have been raised over the way in which arbitrators will conduct themselves in deliberations when they have been directly appointed by one of the parties to a dispute. However, parties rarely abuse the arbitral process to the extent of nominating an arbitrator whose specific function is to vote for the party who nominated him or her. Although parties do appoint arbitrators whom they believe are likely to be sympathetic to the case that they wish to advance during the proceedings.
So we've discussed the grounds for challenge, and for our remembrance, I'm going to quickly recap. The grounds for challenge are independence and impartiality, non-disclosure, qualification, nationality, default and incapacity, and misconduct. Those are the grounds for challenge of an arbitrator once a party discovers that it has a basis or one of those grounds that's a reason, and it decides that it wants to challenge the appointment of an arbitrator. The first step it needs to take is within 15 days of that discovery to make a written submission to the arbitral tribunal and share copies of that submission with all the other parties in the arbitration. If the parties agree with the challenge, then the arbitrator is removed without more.
Is Article 15 on appointment of substitute arbitrator. This article provides that where the mandate of an arbitrator terminates under Article 13 or 14, or because of his withdrawal from office for any other reason, or because of the revocation of his mandate by agreement of the parties, or in any other case of termination of his mandate, a substitute arbitrator shall be appointed according to the rules that were applicable to the appointment of the arbitrator.